In the District Court, CRI 2015-044-000325, at North Shore, New Zealand Police, Prosecutor, v. Mark Donald Eric Keane, Defendant, hearing date, May 19, 2015 at 10:04 a.m. Appearances, J. Gallagher, for the prosecutor. Defendant, appears in person. Legal discussion before Justices of the Peace. Mr. R. Cave and Mr. S. Hayworth. Their worships, Mr. Keane, you are here today in respect of two matters. The first matter is that you failed to produce your driver's license when requested to do so by an enforcement officer, that is the first charge. The second charge is that you drove a motor vehicle at a speed exceeding the 50 km speed limit. Now we notice that you pleaded not guilty on the 17th of March. Do you maintain that not guilty plea? Mr. Keane, the defendant had entered a not guilty plea at that time. I don't understand any of this. Their worships, well, you did plead not guilty that day, we were here that day and we heard your not guilty plea by your solicitor. And you are ready to proceed with the judge alone trial today? Mr. Keane, I'm ready to hear the evidence and, their worships, you're ready to proceed with the trial, so you'll give your evidence and the police will give their evidence and we'll make a decision. Mr. Keane, well, I'm still awaiting to have a verifiable claim before me. Sergeant Gallagher, sir, the police are ready to proceed. Their worships, the police are ready to proceed. Right, we'll stand this matter down, we're just going through the list. So Mr. Keane, just before you do go back to your seat, now we are aware that we have viewed a video on YouTube that was linked to the proceedings on that day, the 17th of March, in this court, North Shore District Court. Now that video was taken without our permission or knowledge, in other words, it was covertly done by you, and despite the warning that was earlier given by the court registrar at the beginning of the proceedings that day and also the signs outside on the door, you proceeded to video us that day. We have viewed that video on YouTube, and it was done by you. We know that. So Mr. Keane, you are ordered, it's a court order, you are ordered to remove that video from YouTube and you must do. Mr. Keane, may I have that order in writing, sir? Their worships, pardon. Mr. Keane, may I have that order in writing please, sir, and signed by yourself? Their worships, no, we're giving it to you in court today, right now, verbally. Mr. Keane, can I have it in writing too please? Their worships, no, you will not get it in writing. We're giving it to you. Mr. Keane, can I have your name please? Sergeant Gallagher, sir, can I remind you of Section 365 of the Criminal Procedure Act? Their worships, yes. Sergeant Gallagher, it effectively means that anybody who deliberately or willfully interferes with the court proceedings can be remanded in custody for up to 21 days or a fine of up to $10,000. Mr. Keane, I don't understand this, sir. Their worships, we are aware of that, Sergeant, and we will follow, we may need to follow it. We prefer not to, we prefer that. Mr. Keane, sirs, I do not understand. Their worships, Mr. Keane, please do not interrupt when we're speaking. Mr. Keane, as you wish. Their worships, so you are ordered to remove. Mr. Keane, as you wish. Their worships, that YouTube video by 5 p.m. tomorrow, that's Thursday the 21st of May. If you do not remove that video from YouTube, then you may be held in contempt of court, and just as the sergeant has just said, there is the punishment for that, for being in contempt of court, can be up to 3 months imprisonment. And, Mr. Keane, can I ask a question, sir? Their worships, you may now ask a question. Mr. Keane, where does this court derive its authority over myself, a man? Their worships, Mr. Keane, we have authority to preside in this court. That authority is given and we're not going to go through that. We don't need to do that. We are here. Mr. Keane, I wish to understand this fully and completely. Their worships, well, you could actually have asked a solicitor before you came into this court. Mr. Keen, I have attempted to seek legal advice and had no success. Their worships, well, we're not here to give you legal advice. We're here to preside in the part of the judiciary. Mr. Keen, all right. Their worships, so we have given you that order, so that's number one. The other thing we have heard today, yes, before you came into this court you saw the signs, or you would have seen the signs on the door that you were not to have the phones on and not to record in court. Now we have received no requests for any videoing today or any recordings in court today. Now to ensure that you understand the importance of our order, that you're not to redo that, we're going to make sure that you sign an acknowledgement. Mr. Keen, really? Their worships, yes. Mr. Keen, how are you going to? How are you going to ensure that I sign something, sir? Their worships, so I'm going to ask the registrar to give you this acknowledgement so that you are aware of the order. We'll give you a copy of this. Mr. Keen, I wish to take that away and have it. Their worships, no, you won't have the opportunity of that. You can sit down and read that. Mr. Keen, I don't understand this unless I get some legal counsel in regards to reviewing it, sir. Their worships, Mr. Keen, I suggest that you have a seat in front of you and read that. We'll give you considerable time for you to read that. Mr. Keen, I feel completely and totally unjustified in having to attend this matter in regards to being pulled over apparent legislative rule of a society. Sergeant Gallagher, sir, that can be dealt with during the hearing. Their worships, no, we're dealing with it now, Sergeant. We just, Mr. Keen, if I got to. Their worships, we want to follow this right. Mr. Keen. Mr. Keen, I was trespassed upon that day, sir. I was wronged. Their worships, Mr. Keen, we're not interested in that. We're interested in this possible contempt of court. That's a serious matter. So I suggest that you. Mr. Keen, I don't understand. Their worships, well, don't you understand what serious means? Mr. Keen, I don't understand what contempt of court, and I don't understand where this court gained its jurisdiction over myself as a man, sir. Their worships, well, contempt of court is when you don't, Mr. Keen, when you are contempt of court it means that you are not obeying the rules of this courtroom. When, Mr. Keen, I don't believe I'm in under any subject to jurisdiction to obey any other man or woman, sir. Their worships, well, you are. You're inside this courtroom, you're under the rules of this courtroom. Mr. Keen, I'm at this courtroom, sir. Their worships, Mr. Keen, we're not arguing with you. Read that. If you don't want to read that, we'll warn you, again. Mr. Keen, sir, the capitalization in this name, is that to refer to capitis dominutio maxima, media, or minima? Their worships, just read the form please, Mr. Keen. Mr. Keen, well, can you clarify what these words mean? Their worships, I'm not interested in playing, Mr. Keen, I need what the author's interpretations of these words are, sir. Their worships, what don't you understand in the form? Mr. Keen, is this written in formal English or legal English, sir? Their worships, it's written in English. Mr. Keen, which type? There are 3 forms. Their worships, we're not interested in that. It's written English, Mr. Keen. Read it. Mr. Keen, I do not understand what type of, their worships, you don't understand English. Mr. Keen, you're coming very close. I'm going to warn you once more, Mr. Keen. If you do not read and at the end of that sign that acknowledgement, we may have you, Mr. Keen. I require leave of court for 5 minutes, sir. Their worships, we may take you, we may have you arrested and held in contempt of court today, so just be aware of that. So just take care, read that form. We're warning you. Mr. Keen, am I not to get a copy of this? Their worships, yes, we will give you a copy of it. Mr. Keen, I will what? Their worships, we will give you a copy of that once you have signed it. Mr. Keen, absolutely, thank you. Who's placing this order? Their worships, we are. Mr. Keen, can I have a name and a signature on it? Their worships, no. Mr. Keen, is it a lawful order then, sir? Their worships, we're requiring you to sign it, Mr. Keen. Have you read through it yet? Mr. Keen, I'm getting through there, sir. Their worships, please read it. Mr. Keen, I believe this may be setting myself up for self-incrimination by signing it, sir. Their worships, not self-incrimination. Mr. Keen, well you're apparently making statements with saying, I made, so therefore you're ascertaining that I'm taking some liability. I want to know who accepts reverse liability, should it come back. Their worships, Mr. Keen, read it. It's a statement of fact. Mr. Keen, under duress and protest I shall sign this. Their worships, have you got a bureau? Mr. Keen, pardon me. Their worships, do you have a bureau? Mr. Keen, of course, sir. Their worships, you have, thank you. I will ask the registrar to give you a copy and at the same time take the copy from the acknowledgement from you. Mr. Registrar, please take that with you. Mr. Keen, it should not take you that long to sign the form. Mr. Keen, I'm copying what I'm doing on my copy as well, sir, for my records. I require leave of the court for 5 minutes, if I may, sir. Nature calls. Their worships, now, Mr. Keen, thank you for signing that. Mr. Keen, you're welcome. Their worships, now, also just to ensure that there is no recording today, we require you to hand your phone or phones to the registrar. Mr. Keen, sir, you're asking me to give up my property, are you, sir? Their worships, we're not asking, we're ordering. We're ordering you to. Mr. Keen, can you put that order in writing please, sir, and sign it? Their worships, no, I'm not putting it in writing. We're telling you, you're inside our courtroom, we're requiring you. Mr. Keen, would I be able to get a transcript or a copy of these proceedings today? Their worships, you can do. Mr. Keen, where from? Their worships, they come from the transcription service. Mr. Keen, at what cost and how? Their worships, well, I don't know that. Mr. Keen, well, their worships, sorry, you'll be, Mr. Keen, I need to keep records obviously, sir, that's all. Their worships, Mr. Keen, you have been ordered to hand your phone or phones to the registrar. Mr. Keen, sure, I can do that right now if you wish. Their worships, thank you. Mr. Keen, will I get a receipt for these items? Their worships, no. They'll be held in court, they'll be safe. So they must be switched off. Are they both switched off? Mr. Keen, well. Their worships, are they switched off? Mr. Keen, off. Their worships, they're both off. Thank you. Mr. Keen, would you like me to take the batteries off? Their worships, no. Well, it's not necessary. If you say that they're off, we accept that. Mr. Keen, do you want to hold on to those for me please? What's your name? Registrar, my name is Reese. Mr. Keen, please. Thank you, Reese. Their worships, they will be held in court and given back to you, all right? Mr. Keen, fantastic stuff. Their worships, now Mr. Keen, we're not proceeding with your thanks you for that. Mr. Keen, you're welcome. Their worships, can you please return back, we're just going through the list at this stage. Mr. Keen, am I allowed to leave and go to the toilet at all? Their worships, you may do, yes. Mr. Keen, great. Their worships, and we'll call you again when we're ready to proceed with your trial. Court adjourns, 10:37 a.m. Police v. Keene, CRI 2015-044-000325, May 19, 2015.